There is no binding law in America which imposes gay marriage upon all 50 states. It simply does not exist. This statement is a legal fact. If you want to know the legal constitutional truth of this matter, then listen carefully to the entirety of the following presentation. Now, you might point to the recent Supreme Court of the United States gay marriage ruling. That ruling, Obergefell versus Hodges, is described in Wikipedia in this way: a landmark United States Supreme Court case in which the court held in a 5-4 decision that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment to the United States Constitution. But let us examine the Due Process Clause and the Equal Protection Clause, since this is what the Supreme Court decision was based upon. The Due Process Clause is defined in this way by Wikipedia. The 5th and 14th Amendments to the United States Constitution contain a due process clause. Due process deals with the administration of justice, and thus the Due Process Clause acts as a safeguard from arbitrary denial of life, liberty, or property by the government outside the sanction of law. That's important. The Supreme Court of the United States interprets the clauses, however, more broadly because these clauses provide 4 protections. Listen to the protections: procedural due process in civil and criminal cases, substantive due process, a prohibition against vague laws, and as the vehicle for the incorporation of the Bill of Rights. Due process ensures the rights and equality of all citizens. Okay, all of that is true. However, there is no law at the federal level redefining marriage as including homosexual relationships. There can be no, quote, due process for something that does not even legally exist in the first place. So the rights and equality of homosexuals as U.S. citizens is guaranteed under the U.S. Constitution. I have no problem with that. However, the U.S. Constitution never addresses the definition of marriage. The definition of marriage is a self-evident truth from the founding of our nation until now. Marriage is between a man and a woman. The Due Process Clause cannot be used to protect something that does not exist in the first place. There is no federal law defining marriage as between 2 men or 2 women. Now let's look at the Equal Protection Clause. Again, let's look at the Wikipedia definition. The Equal Protection Clause is part of the 14th Amendment to the United States Constitution. The clause, which took effect in 1868, provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. Now, as we continue researching the Equal Protection Clause, what we discover is that its original purpose was to ensure citizenship rights to the freed slaves after the Civil War. The Equal Protection Clause has nothing to say, by the way, about the definition of marriage or the redefining of marriage. There is no law at the federal constitutional level that redefines marriage as between homosexual partners. Therefore, there cannot be equal protection for something that does not exist in the first place. Now, if one believes otherwise on these matters, then we must say that there has to be equal protection for a bigamist, or a polygamist, or one who wishes to marry a consenting child, or one who wishes to marry an animal. You see, equal protection would have to be applied to these aberrations of marriage and relationships. There's no way around it, unless we are willing to say that homosexual marriage is to be given special protections above and beyond the protections afforded to the ones that I just mentioned. Of course, if we give special protection only to homosexual marriages, then we have nullified the entire spirit of the Equal Protection Clause. No, the Equal Protection Clause has nothing to do with protecting so-called homosexual marriage, precisely because it doesn't exist. There is no federal law in America defining marriage as between 2 men or 2 women. You will not find that law anywhere in the Constitution or in any federal law. It is non-existent. So, the Supreme Court of the United States gay marriage ruling is not law. The Supreme Court cannot make law. It can only rule upon the constitutionality of existing laws that have been made by Congress and signed off on by the President. That is what the Constitution says. And there is no federal law defining homosexual marriage. In fact, the only federal law the United States has ever had that defined marriage was the Defense of Marriage Act, proclaiming that marriage was between a man and a woman only. Now, that law was passed by Congress and signed into law by Bill Clinton. But in 2013, the Supreme Court struck down that law, proclaiming that the federal government, and that includes the Supreme Court, has no constitutional authority to define marriage. They said only the states have that right. Do you want to hear what the same 5 justices who gave us the gay marriage ruling in June of 2015 said back in 2013 in U.S. versus Windsor? Here are just a few of the many similar statements. You can look it up online yourself in the DOMA ruling, the Windsor versus U.S. ruling. Here's what they said. They said, quote, "Regulation of marriage is an area that has long been regarded as a virtually exclusive province of the states," end quote. Quote, "Each state as a sovereign has a rightful and legitimate concern in the marital status of persons domiciled within its borders," end quote. Quote, "The definition of marriage is the foundation of the state's broader authority to regulate the subject of domestic relations," end quote. Quote, "The states at the time of the adoption of the Constitution possessed full power over the subject of marriage, and the Constitution delegated no authority to the government of the United States on the subject of marriage," end quote. Quote, "The whole subject of the domestic relations of husband and wife, parent and child, belongs to the laws of the states and not to the laws of the United States," end quote. Quote, "Consistent with this allocation of authority, the federal government, through our history, has deferred to state law policy decisions with respect to domestic relations," end quote. Quote, "The significance of state responsibilities for the definition and regulation of marriage dates to the nation's beginning. For when the Constitution was adopted, the common understanding was that domestic relations of husband and wife, parent and child, were matters reserved to the states only," end quote. And then finally, quote, "Federal intrusion on state power is a violation of the Constitution because it disrupts the federal balance," end quote. People, this is not rocket science. Number one, the Supreme Court cannot make law. It can only interpret the constitutionality of existing law. Number two, the Supreme Court has not ruled on any federal law defining marriage as homosexual. There is no federal law doing such a thing. Number three, the Supreme Court said in the Defense of Marriage Act that if any federal agency ever attempted to define marriage for the states, it would be unconstitutional and illegal to do so. Thus, they struck down the Defense of Marriage Act. Number four, to now say that gay marriage is the law of the land is a display at least of complete ignorance of American constitutional law, and at the most, or at the worst, it is an attempt to absolutely deceive the American public. Number five, and this is important, no state, no county clerk, no U.S. judge, no pastor or otherwise is obligated to perform or acknowledge a gay wedding based upon the latest Supreme Court travesty of an illegal and unconstitutional opinion. That ruling was no less a travesty than the celebrated Supreme Court Dred Scott ruling. So I will close with the words with which I opened this video. There is no binding law in America which imposes gay marriage upon all 50 states. That law simply does not exist.